What's up, y'all? You're watching Union Minded. I am your host, Eric, and today I want to take a bit of a dive into the June 1st decision by the Supreme Court, an 8-1 decision, who, in that 8-1 decision, ruled in favor of the corporations against the Teamsters who were on strike, and ruled that companies can sue the union for losses incurred during a strike. It was a hell of a blow. I'm sure that it sent shockwaves through the scary folks that lead certain unions, folks who tend to bow down rather than fight back, who believe that unions are a thing of yesteryear and aren't really necessary these days, and they're more like a temporary hiring agency. To those type of folks, I'm sure that ruling sent shivers down their spine, like Genuine did in that song when he Ride That Pony, when he said send chills down your spine. I'm sure that's what it was like. But anyway, let's dive on in. We're going to talk about that. So I'm reading Reuters, and it says, this is a report that came out June 6th. Sorry I didn't get to it sooner. Life. The U.S. Supreme Court delivered another blow to American workers and the labor movement on Thursday. Even though the court did less to erode employment rights than had been widely expected, the June 1st ruling came in a case backed by conservative and business lobbying groups that aimed to seriously curtail workers' long-standing right to strike and to pare back the National Labor Relations Board's original jurisdiction over labor relations and certain workplace disputes. Conservative and business lobbying groups. Now the court, it's 9 people sitting on the bench, right? This decision was an 8-1 decision. They say it's 6-3 is the number on the court. Conservative to liberal, right? 6-3. Then how in the world did you get an 8-1 vote if it's a 6-3 court? Shouldn't it have been a 6-3 court? That should inform you of something. Now, I've read about the Great Compromise of 1877 long ago, but I want to retouch that because it kind of signals where the change happened and why both the Democratic Party and the Republican Party agree when it comes to business decisions and why that is. So I want to jump into that really quick so that we can get a little bit of understanding of what was the Compromise of 1877. The Compromise of 1877 was an informal, unwritten deal that settled the disputed 1876 U.S. presidential election. Through it, Republican Rutherford B. Hayes was awarded the White House on the understanding that he would remove the federal troops from South Carolina, Florida, and Louisiana post the Civil War during Reconstruction. So what was happening in the South during Reconstruction was that the black residents who were former slaves and now are freedmen were winning elections and were coalescing together and building up towns and building up wealth and building up their own slice of the pie of the South, for all that they built, for all those years and years and years and years and decades of slavery and all that they did to build this country up. They were getting a slice of the South. And the Southern Democrats, who were the KKK party back then, we could talk about, that's another whole video, what happened in the 70s. But anyway, the Southern Democrats really didn't like the federal troops being there protecting these black towns and keeping these southern racist towns from basically burning it all to the ground and making sure that blacks never gained a foothold in the South. They made a deal with the Northern Republicans, who were industrialists, who were fighting with unions and their own immigrants that were coming from Europe and coming to work in mines and to work on the railroads and all this other stuff. And so the unions were starting to gain some power in the North, and the North Republican, the businesses in the North, wanted to undermine that. And so what they did was make a deal for this U.S. presidential election with the Southern Democrats. And that deal stated, we're going to pull these troops out of here, and what you're going to do is help us with beating these unions by forcing conditions to basically create a great migration, which allowed for the former slaves to move up north and compete directly with the union workers in the North and drive wages down, because companies were pitting people against each other, just as they do today, just as they did in that ruling. So why was the Compromise of 1877 significant? We spoke about it a little bit, but I'm going to read into what Gugaleo has to say. The Compromise of 1877 effectively ended the Reconstruction era. Southern Democrats promised to protect the civil and political rights of black people were not kept, and the end of federal interference in the Southern affairs led to widespread disenfranchisement of black voters. What were the three major components? The last remaining troops from the South would be removed, and legislation would be passed to assist in the industrialization of the South. Again, this was all to just bring business together, Southern agriculture and Northern industry. Bring it together and dominate working people, farmers and miners alike. So let's continue to read on Reuters about this Supreme Court decision. I just wanted to touch on that because I think it's important for context. The 8-1 decision largely preserves the existing legal framework in those areas, contrary to prior expectations. Still, the ruling makes it easier for businesses to sue unions and recover damages for economic harm related to work stoppages. Let me let you know something, union members. Your labor is the only power you have. It's the only strength you have. Withholding your labor is the only thing that hurts these very, very wealthy business owners. It's the only thing that's ever harmed them. This ruling is not going to change the fact that we own our labor. I don't have to work for you. We own our labor, and we could stand in solidarity and stop that if we wanted to. This ain't gonna, it's very upsetting. Anywho. Still, the ruling makes it easier for businesses to sue unions and recover damages for economic harm related to work stoppages, and it creates some uncertainty about when and how workers can engage in a legal strike, depending on the nature of the employer's business. This dispute involved a strike by about 45 members of Teamsters Local 147, a union of truck drivers for Glacier Northwest, Inc. The Washington State Company also does business as Cal Portland and is one of the largest producers of cement and building materials in the country. The August 2017 work stoppage started while some of the company's mixing trucks were filled with concrete, and Cal Portland ultimately took a loss when the product hardened and became unusable. The union filed a labor board charge against Glacier afterward, alleging management retaliated by disciplining certain workers after their strike. Glacier then filed its own complaint in state court, arguing that the drivers conspired to destroy its property by showing up to work and then walking off after cement was mixed, knowing it could harden and become useless. The union argued, based on precedent, that the dispute should be heard by the NLRB in the first place rather than a state court, adding that the law doesn't require unions to inform employers about the timing of a work stoppage. Congress created the National Labor Relations Board in 1935 and an expert forum with primary responsibility for interpreting laws governing the relationship and the natural power imbalance between workers and employers. So these are the laws that were written to protect us in the early days of the labor fight after culminations of really, really bloody battles. 1935, you got to remember, this fight began during the beginning of industrialization. We're talking about the 1850s. And 1935 is already 80 years into the fight of trying to gain legislation and labor rights. So you're talking a long time coming and a long time precedence. Anywho, I'm going to put this article in the comment section, but just the key thing to take away from this to me is 8-1 tells you that court is not 6-3 when it comes to corporate America and their business. That's the key takeaway. Now, I'm curious if this rebel rouser O'Brien from the Teamsters had anything to say. Let's go to their website and find out. So here on the Teamsters website, it says O'Brien, SCOTUS attacks all U.S. workers. Let's take a look at that real quick. The following is a statement from Teamsters General President Sean M. O'Brien on the Supreme Court's ruling today in Glacier Northwest Inc. versus International Brotherhood of Teamsters Local Union number 174, which opens the door for corporations to sue their own workers. And here's what he had to say. The political hacks at the Supreme Court have again voted in favor of corporations over working people. These corruptible justices should be ashamed of themselves for throwing out long-standing precedent and legislating from the bench. The ability to strike has been on the books for nearly 100 years, and it's no coincidence that this ruling is coming at a time when workers across the country are fed up and exercising their rights more and more. Make no mistake, this ruling has everything to do with giving companies more power to hobble workers, if any attempt is made to fight back against a growing system of corruption. The Supreme Court is not upholding the law, nor is it advancing the American people. The Supreme Court justices are ruling on behalf of billionaires alone, the very ones they socialize with at cocktail parties and who they owe their jobs to in the first place. American workers must remember that their right to strike has not been taken away. All workers, union and non-union alike, will forever have the right to withhold their labor. The Teamsters will strike any employer when necessary, no matter their size or the depth of their pockets. Unions will never be broken by this court or any other. Today's shameful ruling is simply one more reminder that the American people cannot rely on their government or their courts to protect them. They cannot rely on their employers. We must rely on each other. We must engage in organized collective action. We can only rely on the protections inherent in the power of our unions. Whew. Smoke. Hear, hear. That's what I got for you today. My name's Eric. You're watching Union Minded. Please keep in mind that the fight's not left and right. It is up and down, and it's going to take solidarity to win always. Each one, teach one. Get out there and reach one. And there can be no union without you and I, front and center. Let's go. Peace.